Today we're going to talk about what is the difference between probate and successions in Louisiana. Here in Louisiana, we're a civil law state. And so although the terms succession and probate have similar procedures and laws in Louisiana as in other states, the terminology is different. In other parts of the country, the word probate is used. In fact, you're going to hear a lot of that in the national media. And they will normally say you want to avoid probate. Well, probate in other parts of the country has a very broad meaning. In other parts of the country, probate means the proving of a valid legal will, the payment of the debts of the person that died, and the transfer of the ownership interest from the decedent to the persons either named in the will, or if there is no will, to persons that the law says is entitled to ownership. Here in Louisiana, the word probate has a much more restricted meaning. It only means the proving of a valid legal will. That's it. That's all probate does, is simply proving a will if one exists. The word succession has a more restrictive meaning. It means the transferring of ownership from the deceased person to either the person named in the will, or if there is no will, the person that the law says is entitled to ownership through a legal proceeding. It's always important to remember that a will under Louisiana law does not automatically transfer ownership. It is the actual filing of a succession proceeding that allows us to transfer the ownership, complying with what the will said to be done. To accomplish a succession, there are 4 general ways we can do this. The easiest way is what's called a small succession affidavit. For this option, there are a couple of requirements. The value of the estate, which is the gross value, must be less than $125,000. And there cannot be a will. If there is a will, there's an exception to the rule. And that is where the will would have been the same had you not had a will at all, under the laws of intestacy, meaning dying without a will. If you meet those 2 requirements, you can save a lot of time, money, and effort, because simply an affidavit needs to be signed and recorded if there's real estate. The second option is to file an actual succession. The succession will involve different options here. The first is to do a succession where no executor is appointed or administrator is appointed. We would do this in probably 90% of our cases because there is no need to appoint an executor. Now, we know what the assets are. We know what the debts are, if there are any. We know there's no fighting. We know who the ownership interests are. And so we simply file a succession and say, the will says everything goes to John, Mary, Sally. And the court issues a judgment saying John, Mary, and Sally gets the assets. There is no executor appointed. So we skip the executor. This saves some time, some money, and some effort. Option 3 is where we go in and need to do a succession with an executor. But in this case, we're going to appoint what we call an independent executor. Let's say you have a lot of debts and you need to negotiate them or you need to litigate them. You would need an executor to do that before you place people into ownership because they don't know if they want to acquire all this debt. Or let's say there's some pending litigation, there's a malpractice suit, or there needs to be a division amongst the children. We've got 100 heirs out there or legatees, and we need to divvy everything up, so we got to liquidate it. We need an executor to do that. In this particular case, we appointed an independent executor. An independent executor, they need to be appointed by the court, but they don't have to get court approval on everything. So although there's an executor, it makes it cheaper. We have less procedures to do under Louisiana law. The last option is probably the least desirable, and that's what we called in our earlier segment probate in other states. And that's where we appoint a regular executor. A regular executor would be appointed if, let's say, the will didn't provide for an independent administration, or we couldn't get all the heirs to agree to an independent administration. A regular administration involves appointing an executor or an administrator. But in this particular case, if you can't be named independent because of the will and by agreement of the parties, that leaves us with the executor or administrator having to administer the estate, and every time they do something, they gotta get approval from the court, and a lawsuit has to be filed. So there's a bunch of lawsuits being filed to approve every step of the way, including the finalization and then final possession. That's what drives up the cost, takes more time, money, and effort that we're trying to avoid. Thank you for watching. If you found this video useful, please feel free to give it a thumbs up, or feel free to share it with your friends or family. Also, if you've enjoyed it, please feel free to hit the subscribe button so you can get further updates. If you have any questions, you can leave them in the comments box below, or feel free to contact us at our office at 225-769-4200. Thank you and have a great evening.